This is not a scandal. It is not a leak. It is not another episode in the endless cycle of American political outrage. What is happening right now is something far colder, far rarer, and far more dangerous. The constitutional system has begun to move on its own. For decades, the United States has survived crises by absorbing them into politics. Courts waited, Congress delayed, presidents ran out the clock. Time was the shield, attention faded, power remained intact. That pattern just broke. Tonight, Washington is not reacting like a city caught in partisan theater. It is reacting like a system under strain. Security perimeters are expanding. Lawmakers are being pulled into closed-door briefings. Emergency protocols are being quietly reviewed. These are not gestures for cameras. They are institutional reflexes, and that distinction matters. Politics is loud, it leaks, it performs. Constitutional stress is silent, it locks doors, it narrows movement, it accelerates process. What makes this moment unprecedented is not the personality at the center of it. It is the procedure. For the first time, a federal court has treated presidential conduct not as something to be debated later, but as something the system cannot safely contain any longer. This is not Congress attacking a president. This is not an election year stunt. This is the judiciary reaching a conclusion that delay itself has become a risk. When courts act this way, it is not because they want to intervene. It's because every other buffer has failed. This is the moment the system stops bending and pulls the emergency brake. And once that brake is pulled, there is no return to normal. The federal trial was proceeding as trials always do, measured, procedural, constrained by rules that are designed to drain emotion from power and reduce conflict to evidence and law. Nothing about the room suggested rupture. A judge on the bench, a jury seated, cameras waiting for routine developments. Then the boundary was crossed. When U.S. Marshals move inside a live federal courtroom, it is not a gesture and it is not theater. Marshals are not decorum officers. They do not intervene for tone, posture, or advocacy. They intervene only when criminal conduct is believed to be unfolding in real time. That distinction is critical. A procedural violation can be corrected. An objection can be sustained. A mistrial can be declared. Perjury cannot be managed that way. Perjury is not strategy. It is a felony. And when it occurs under oath in open court, before a jury and under active judicial supervision, the court loses the option to simply continue as if nothing happened. The moment the marshals stepped forward, the trial ceased to be about the defendant alone. It became about the integrity of the judicial process itself. This was not a private admonishment or a sealed reprimand. It unfolded publicly, in full view of jurors and cameras, eliminating any possibility that the event could be contained or quietly resolved. From that instant forward, the courtroom was no longer adjudicating a case. It was identifying a threat to truth under oath, to judicial authority, and to the system that depends on both to survive. Judges are trained to do one thing above all else: stay out of politics. Their authority depends on restraint, on patience, on exhausting every procedural option before escalating. Courts do not rush, they defer. They narrow questions. They give defendants room to correct, clarify, and comply. That is the default posture. Escalation only occurs when that posture becomes untenable. The threshold is not embarrassment or controversy. It is systemic risk. When a court determines that false testimony is not incidental but sustained, not accidental but strategic, the question shifts from advocacy to obstruction. Obstruction matters because it is not merely a crime against a case. It is a crime against the court's ability to function. When obstruction appears tied to executive authority, when the possibility exists that lawyers are not acting independently but shielding power, the judiciary cannot resolve the issue internally without compromising itself. Appointing new counsel might preserve the appearance of continuity, but it does nothing to address whether the obstruction was directed, coordinated, or intended to nullify judicial authority altogether. At that point, delay is no longer neutral. Delay becomes exposure. Courts are not permitted to trade time for stability when time itself is being used as a weapon. That is why escalation occurs. Not because judges want to intervene, but because failing to act would signal that the rule of law is optional under sufficient pressure. When a court reaches that conclusion, it is authorized to activate mechanisms beyond the trial itself. not as punishment, as preservation. What happened next is often misunderstood because it is described using political language, when in reality it is a judicial act. Evidence transmission is not a leak. It is not a referral memo. It is not a judge expressing concern or offering an opinion. It is a formal procedural step in which a court assembles, certifies, and transfers material that has already been entered under oath into the judicial record. Every item is authenticated. Every timestamp is preserved. Every chain of custody is intact. This is the opposite of speculation. The materials involved are not narratives. They are artifacts. Transcripts capturing sworn testimony line by line. Metadata showing when communications were created, accessed, and altered. Emails previously denied under oath. Audio recordings entered as exhibits. Body camera footage documenting enforcement actions inside the courtroom itself. What makes this moment extraordinary is not the existence of evidence, but the decision to transmit the record in its entirety rather than distill it into summary or recommendation. Historically, courts have avoided that move. During Watergate, judges waited while Congress investigated. During Clinton, accountability flowed through political channels first, with courts maintaining distance. Here, that sequence reversed. The judiciary did not wait for politics to decide when it was safe to act. It concluded that safety required immediacy. By sending the full record, unfiltered and complete, the court collapsed the traditional buffer of time. Debate did not disappear, but delay did. The timeline shifted from months and years to hours and days. At that moment, the political calendar stopped mattering. The clock that took over was judicial, and judicial clocks do not pause. What followed the court's transmission did not create impeachment, it unlocked it. Long before the evidence moved, the architecture was already in place. A formal impeachment resolution existed, drafted, structured, and waiting. It did not move because impeachment is not driven by outrage or headlines. It moves on arithmetic. Votes are the only fuel, and for months there were not enough of them. Lawmakers hesitated not because allegations were unclear, but because exposure was uncertain. Defending a president is survivable when facts are disputable. It becomes dangerous when evidence is certified. That is the pivot point. Judicially authenticated material removes ambiguity. It collapses the space between belief and record. Before the court acted, lawmakers could argue motive, timing, or politics. Afterward, they had to confront transcripts, recordings, and sworn documentation that could not be dismissed as partisan interpretation. That shift matters because congressional behavior changes when risk becomes personal. The question stops being whether impeachment is politically wise and becomes whether silence can be defended under oath, on camera, and in a campaign ad. Once that calculation flips, momentum accelerates on its own. Names appear on resolutions not quietly but publicly. Numbers climb not through persuasion but through gravity. When a majority is reached, leadership no longer controls the process. The math does. At that moment, impeachment stops being a threat or a theory. It becomes an inevitability produced by counting, not emotion. And once the numbers lock in, delay is no longer a strategy. It is a liability. For years, the dominant survival strategy inside the Republican Party had been delay. Wait for the noise to pass. Question motives. Demand more time. Avoid commitment while letting public attention drift elsewhere. It worked because uncertainty provided cover. As long as facts could be framed as disputed, loyalty carried less risk than defection. That balance collapsed the moment the court record entered the public process. Judicial evidence changes incentives because it eliminates plausible deniability. Once transcripts and recordings exist under oath, defense becomes exposure. The image of attorneys being escorted out of a federal courtroom did more than any argument could. It converted abstraction into fact. No talking point can erase a visual that communicates criminal consequence. Lawmakers understand this instinctively. They do not ask whether a narrative can be spun. They ask whether it can be survived. At that point, loyalty ceases to be a principle and becomes a liability. The internal calculation turns blunt. Can this be defended on television? Can it withstand cross-examination? Can it be explained to a jury, a donor, or a voter without personal risk? When the answer is no, alignment shifts rapidly. Defection accelerates not because beliefs change, but because exposure does. The party does not fracture over ideology in moments like this. It fractures over liability. And once that fracture appears in public, it does not heal, it widens. At the moment restraint mattered most, Donald Trump chose escalation. His response was not calibrated messaging or legal containment, but volume, continuous posts, personal attacks, absolutist language delivered in real time. In ordinary political conflict, this style creates noise and dominates attention. In a legal crisis, it does the opposite. Every statement becomes a record. Timing, wording, and intent are preserved automatically, stripped of context, and frozen for analysis. Speech that once functioned as political theater crosses a line when it targets judges, challenges lawful authority, or calls for resistance to constitutional processes. At that point, it is no longer opinion. It is potential intimidation. It is potential incitement. And critically, it is self-generated evidence. The phrase threatening civil war is not evaluated as rhetoric by security institutions. It is assessed as a signal. Signals change behavior. They trigger monitoring, elevate threat levels, and reshape risk assessments. This is why Trump's communication strategy accelerates his exposure rather than containing it. Prosecutors do not need interpretation when intent is articulated publicly. Courts do not infer state of mind when it is declared. What once relied on ambiguity now produces clarity. Instead of mounting a defense, Trump is creating a chronological narrative of escalation with his own words. He is not contesting the record. He is expanding it. And in doing so, he is supplying the very material that constrains him. When Washington tightens its perimeter, it is tempting to read the move as symbolism, a visual meant to project authority or calm nerves. That assumption is wrong. Real security preparations are operational decisions, not messages. They are based on threat assessments, not optics. The lesson of January 6th permanently altered how federal agencies interpret risk. What once might have been dismissed as rhetorical excess is now treated as a precursor. Words are not evaluated for tone. They are evaluated for effect. When a sitting president uses language that frames constitutional enforcement as existential conflict, security planners do not debate intent. They model outcomes. They ask how fast mobilization can occur, how coordination spreads online, how quickly a crowd can turn into a force. This is why law enforcement treats speech as a signal. Signals shift posture. They justify surveillance, deployment, and contingency planning. The presence of the National Guard is not about confronting demonstrators. It is about preventing momentum. Visibility deters escalation. Layered security buys time. The goal is not engagement but insulation, creating enough friction to stop a volatile situation from cascading. That posture reveals something crucial. The system is no longer preparing for external threats or routine protest. It is responding as it would to an internal destabilizing force. When institutions behave this way, it is not because they expect chaos, but because failing to prepare for it would be negligence. Washington is not locking down out of fear. It is locking down because it recognizes the pattern and refuses to repeat it. Part 9. Precedent, not personality. What survives after this? At this stage, the crisis is no longer defined by a single outcome. It is defined by convergence. 3 independent mechanisms are now moving at the same time: impeachment in Congress, criminal exposure through the courts, and constitutional incapacity under the 25th Amendment. None of these paths requires the others to succeed. None of them depends on cooperation from the president. That is what makes this moment structurally different from past presidencies under stress. The Senate's eventual vote, while consequential, is no longer the sole determinant of accountability. Even an acquittal cannot rewind sworn records, sealed evidence, or criminal timelines already in motion. Once authority fractures across institutions, it does not recombine. The presidency loses velocity. Orders face resistance. Decisions trigger litigation. Power becomes conditional rather than assumed. That shift extends far beyond one individual. Future presidents will operate under the shadow of this moment, aware that time is no longer an unlimited shield, and that courts will not always wait for politics to resolve existential risk. The long-term consequence is not partisan victory or defeat. It is a recalibration of power. For decades, authority outran law through delay. That advantage is gone. What remains is process, methodical, indifferent, and relentless. And that leads to the only question that matters. If a president can threaten the rule of law and survive unchallenged, then the rule of law is already dead. But if the system responds now under maximum strain, then the precedent will live, and with it, the Constitution itself.